what are the penal provisions under the Trademarks Act? So, first and foremost, Section 103 and 104 of the Trademarks Act. So, what does Section 103 says? Section 103 of Trademarks Act gives you penalty for applying false trademark, falsification of trademark, trade description, trade dress, etc. So, as per this section, if somebody has copied a trademark that belongs to another person, falsifying or even deceptively similar trademark, because you have to understand under trademark the comparison is that the trademarks need not to be exact replica of each other. You do not have to keep them side by side. This is a settled judicial precedent that if for a third person, if they think that this is the same product as the earlier product, it has to be from a reasonable eye. So if there is a confusion that is leading there, and most importantly, if they are product in the same category, then they will be covered under Section 103. And what is then Section 104 prescribes the penalty for selling goods or providing services to which false trademark or false trade description is applied. So this is a charging provision with relation to 103, while 103 defines what are the conditions in which a falsification of trademark will come. 104 prescribes the penalty in relation to it. Now, most importantly, the most important section here is Section 111. So why do you file a complaint under 103 or 104? When do you go for criminal prosecution in comparison to civil proceedings in trademark? So generally there are 2 or 3 cases in which client will approach you. The first would be when somebody has directly copied their good verbatim and is selling in the market. Now, as a business owner, what is my first concern? Yes, I will try to get an injunction from civil court, but my second and most important concern would be not to get the damages, but to stop them immediately. And especially if I do not know where the manufacturer is and who is manufacturing it. For instance, you must have seen a lot of times that when you go to market, there are a lot of these cheap variants of companies which will be selling sports shoes with a different name probably. Now you and I can identify that this is not an original good, but for a third person it is very difficult to identify, especially somebody who is living in a rural area or a smaller city. So how, as a brand owner who has manufacturing and presence in different cities, how will I solve this situation? So what I will do in this situation is criminal complaint is a very good way, because what happens is you immediately give rights to the police to go and seize the goods. I will explain these provisions in detail towards the later half. So forfeiture of goods. Section 111 of the Trademarks Act says that when a person is convicted of an offense under Section 103 or 104 or Section 105 on proof that he acted without intent to defraud, or under Section 104 on proof of the matter specified in the clause. So basically, under this section, what happens is this section gives, irrespective of your intent, if there's a falsified trademark that has been applied to your good, your goods will be liable to be seized. Now, Section 114. This is most important. If the person committing an offense under an act is a company, the company as well as every person in charge of and responsible to the company for the conduct of its business at the time of the commission of the offense shall be deemed to be guilty of the offense and shall be liable to be proceeded against and punished accordingly. So as per this section, if a company is involved in the offense, it's not just the directors, but every employee who is part of the company and who has knowledge and who has a malified intent will be part and parcel of the crime being committed, that is falsification of trademark. Now, Section 115 Clause 4. This is again very relevant because what are you filing criminal complaint for? The idea is not to just get the person who is doing the act arrested, but also to ensure that all the infringing copies that are there of your product, cheaper variant probably, similar variant probably, they should be seized immediately and taken off the market so that your reputation and your goodwill is not harmed. So Section 115 Clause 4 says any police officer who is not below the rank of Deputy Superintendent of Police or equivalent may, if he is satisfied that any of the offences related to in subsection 3 has been, is being, or is likely to be committed, search and seize without warrant the goods, die, machine, plate, other instruments or things involved in committing the offence wherever found, and all the articles so seized shall as soon as practicable be produced before the judicial magistrate of the first class or metropolitan magistrate as the case may be. Now read very carefully, provided that the police officer, before making any search and seizure, shall obtain the opinion of the registrar on facts involved in the offence related to trademark and shall abide by the opinions obtained. So now there's a catch when it comes to proceeding under Trademarks Act. The catch is that before, after filing the complaint, before acting, the police officer will have to take opinion of the registrar of the trademark whether the trademark that you have complained against, the falsification, whether they are similar or not. So in this case, the police officers cannot act on their own. They will have to compulsorily take an opinion from the registrar of trademarks. And this is where most of the complications come, because this is a slow process. Taking opinion of the registrar and takes a lot of time. So in a way, what happens here is then this becomes very similar to civil proceedings. So now there are ways, there are turnarounds, and there are different ways in which we bypass this provision. I'll explain that to you later.